So do we have an officer that actually sees her in the car in the ditch?
One, I don't see that the officer said any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement of her statement in and of itself is insufficient in a passenger seat of a tow truck? How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? Good morning, Ms. Ford.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed for you, ma'am.
I apologize. What's the last name you're on?
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
Yes, Judge. And the statement made statements stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her, no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol, and the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him and finding the vehicle.
did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information.
So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy spoke of the defendant.
So someone sees her in the ditch.
Wait,
I think you might have a different.
Oh,
That's a
sorry,
different
that was
case,
the
right?
wrong case, Judge.
In this
Sorry,
case,
sorry.
she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint your lawyer today so we can have someone take a look at the case for you. Okay? Ramona, do you mind appointing someone for Ms. Ford, please? Just do me a favor. Just take a seat for me in the jury box, will you, please? Okay, so it's a DWI Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right. So her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that
Yeah.
same, well, go ahead.
Have,
Go down to you. Until you get-
so do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the
Oh,
ditch
she
with the
wants-
tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
and the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not gonna corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah, I do.
Okay, well, give
So-
me time.
Yeah, and I'm willing to, if you want, maybe like we can revisit on Monday,
Okay,
because I want to give you time. I want to,
waive her appearance? For Monday?
yeah, I'm going to put her under conditions though, but yeah,
Understood.
okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and we'll do more, I guess, formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run her license, please? And any other prior DWIs?
Your Honor, no prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand? Okay,
Eligible, Your Honor.
great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign the reset, I'll have you meet with Fleshier for your bond conditions. And after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah,
Okay.
she needs to sign the reset, but yeah.